everybody. Welcome to our webinar on how to preserve and grow your wealth in a COVID-19 world. I'm Jessica Forrest, Vice President of Accounts at Top of Mind PR. If you're not familiar with Top of Mind, we're a public relations and marketing firm with clients consisting of real estate companies, law firms, financial institutions, hospitality groups, and nonprofits. Today, we put together this webinar to help provide you with some tips for planning your financial future in this very uncertain time. You will first hear from Sandy Jukel, who is a financial advisor and managing director at Ameriprise Financial. He will give you an overview of the financial markets and the future of retirement planning. Sandy will then turn it over to Carrie Baron and Michael Strohmenger of Baron Strohmenger CPAs, and they will discuss pandemic-related tax strategies. Then you will hear from Ronald Siegel, who is a partner at Brinkley Morgan law firm. He will discuss how to protect your family's wealth by creating a will or living trust. Throughout their presentations, please use the Q&A feature to send us your questions, and we will answer them at the end. Now, without further ado, I will turn it over to Sandy Jukel.
Hello, everyone. Thank you for joining us today. For those of you who don't know me, I'm Sandy Jukel, a financial advisor and managing director with Ameriprise Financial based in Coral Gables, Florida. I help individuals plan to meet their financial needs by developing investment plans and retirement plans around their long-term goals and risk tolerance. We are in such uncertain times, but that doesn't mean your financial goals should be uncertain. The purpose of today's webinar is to give us an overview of the markets and discuss different investment and retirement plans that will help you mitigate the uncertainty. We all know that there have been many factors that could impact the stock market, returns, and this is not the first time an epidemic has had an impact on the stock market. If we look at historical data over the past 40 years, the market's overall resiliency through several major epidemics gives us perspective on the benefits of investing for the long term. For example, over a 38-day trading period during the height of the SARS virus back in 2003, the Standard & Poor's 500 index fell by 12.8%. During the Zika virus, which occurred at the end of 2015 and into 2016, the market fell by 12.9%. Following these epidemics and outbreaks, the markets recovered and hit new highs, just like it has done with the coronavirus. The ongoing impact of the coronavirus is still widely visible, and while the markets may be up, there are still a number of industries that are feeling the impacts more than others. The airline industry, casino and gaming industry, and auto parts and equipment, as well as oil and gas drilling, have all suffered as a result of COVID-19. The insurance, property and casualty, multi-line, life and health industry, REITs, meaning healthcare and the industrials, seem to have benefited amid COVID-19. While you want to buy when the stock market is low, really focus on 5 companies that will either double or increase by 10%. Those are the companies that you want to invest in. I can help you identify those 5 companies. The unemployment impact of COVID-19 has been widespread, and for those who may have lost their jobs, they should think about rolling their 401k into an IRA. As long as assets are rolled directly into an IRA, there's no taxes or penalties applied to your in-service distribution. There are a number of pros and cons to moving your money into an IRA. The pros include more flexibility, more investment choices, and optional income tax withholding, among other benefits. Some of the cons include fees and expenses, as well as age limitations. I would also recommend that anyone with an IRA should do a beneficiary review, and those with a 401k need to rebalance on an annual basis. Sadly, the epidemic has reminded us why estate planning is an essential part of achieving one's long-term financial goals. A proper estate plan should cover financial and non-financial items such as who will raise your children, if you have children, what medical interventions do you want, who do you want making healthcare decisions for you, and who will manage your finances, how end-of-life finances will be managed, and how properly and financial assets will be distributed. A couple more key things to keep in mind as you plan your estate. Choose who should be your estate's representatives and discuss with them what your intentions are for your estate. Be sure you put this in writing. With the pandemic ongoing, be aware that many life insurance policies are now allowing them to be drawn upon early to use for long-term care. Be sure to review any existing 401k IRA plans you own for a beneficiary review annually. Be sure to continually rebalance your 401k IRA portfolio. The biggest mistake many investors make is not rebalancing their portfolio, especially during unique moments in the history of mankind like this pandemic is. A financial planner can bring certainty in times of uncertainty. At Ameriprise, we tailor investment strategies to meet an individual's financial needs and goals. We also offer personalized services for each individual and are always available to answer any questions you have in regards to your portfolio. At this time, I have the pleasure of introducing Carrie Baron and Michael Strohmenger, who are top CPAs, and I'd like to go ahead and introduce them.
Thank you so much, Sandy. It's a pleasure to be here. Thank you so much for attending. Thank you, Jessica. Thank you, Top of Mind PR. I'm happy to start. Today, I want to talk about being able to claim benefits related to COVID, which means that right now, this second, there's probably quite a few of you that are working from home that we can start planning for. I prepared a little presentation on this. And the very first thing that I care about is that if you are working from home, there's strategy to this, meaning you can claim benefits for the business use of your home. And the way that would work would be, it'd be based on a percentage of your home that's actually used for business use. So if your home office is 10% of your home, that means that you can get 10% of any expense that's attributable to your business. So things like real estate taxes, things like your rent, things like cable or internet are going to be a little bit trickier to claim because that's not exclusively used for business. So there's two main ways that you want to be able to claim this. Way one is that you can actually deduct this when it is regular and exclusive use of your business office, meaning not once a month, and also should not be shared space. I'll tell you right now, some of the big things that they look for, they want to try to make sure that there are no beds in the room, also no cribs. So that kind of thing can help you claim this. The second thing is they want it to be the principal place of business. So that should be mainly where you are working out of. The second thing for home office, keep in mind, your home office, there's a 14-day rule, which is very interesting. It means that you can use the business to pay a homeowner for the use of their home. What's very interesting about this is that it means that you get to take a deduction through your business and you do not have to report it as taxable income on your personal. Essentially, I'm saying that your business is getting a deduction for that use of your home. It's based on a 14-day rule, which essentially means that you are allowed to enjoy this. You're getting the benefit for that cost. So the way that I'd recommend you take it is you can plan to space out those payments. Let's say it's 14 days. As long as your home is rented to your office less than 14, it's not taxable. So let's say it's $1,000 per payment. 14 days is your cap, so I would recommend doing a $7,000 payment around June, maybe middle of the year, and another $7,000 around December to space it out. Okay, next thing. You can also claim for the most impactful benefits. Things like health, things like retirement are considered adjustments on your return, better than a deduction, and very different from a credit. So things for health, consider if you're self-employed, you get the benefit of self-employed health insurance. You can get the benefit of HSAs, like health savings accounts. If you're planning ahead for retirement, you can get the benefit for things like IRAs or SEP Simples qualified plans. Those are your pensions, your 401ks. That's very significant. Plan to put your money where you know it's going to be the biggest bang for your buck. The next thing is, as you're planning ahead for this, it's quite possible that you have received COVID relief. If you attended our last webinar on PPP, the Paycheck Protection Program, we talked about how PPP is a loan. It is not taxable income, and the interest expense related to that loan would be deductible. If you were able to get that loan forgiven, under normal circumstances, that would be considered cancellation of debt, which is taxable. Under this circumstance, not taxable income, not considered cancellation of debt. It's pretty cool. For EIDL matters. That's the economic injury disaster loan. This matters. This is the one that you get directly through the SBA. That's, again, you got two versions of the EIDL. The loan, same as the PPP. It's a loan, not taxable income. The interest expense still deductible. If you got the EIDL grant, that's that $10,000 that you were able to get, $1,000 per W-2. So if you got the EIDL grant, that portion is not going to be considered taxable income, and not paying it back is also not considered cancellation of debt. Lastly, unemployment. If you have, go ahead.
The EIDL loan must be repaid, though. That's the difference between the EIDL loan and the PPP loan, is that PPP can be forgiven, EIDL cannot be. You have to pay it back. If you don't pay it back, it's cancellation of debt income and it's taxable.
Correct. And just to distinguish between the two of these, if you had PPP is the one that you got through an SBA provider bank. That's the one that you actually went to a bank for. If you got EIDL is the one that's directly through SBA that you probably went on SBA.gov and did your application. So thank you, Michael. Okay, last but not least, so unemployment. Unemployment is considered taxable income. That means that while you are applying for the unemployment, there is a way that you can plan ahead and you can withhold money from those income payments. So if you'd like to plan ahead to withhold, absolutely you can. Okay, last topic, refinancing. You guys are probably aware that interest rates are very low right now. So if you feel like refinancing, it may be a good time. Where I would tell you to plan ahead, if you are a homeowner, if you own your home and you refinance, that's going to be a reduction of your interest expense, which is incredible. And if you're a homeowner, you own the home, you can get a benefit related to real estate taxes, as well as interest expense on your home mortgage. Under the new tax law, the Tax Cuts and Jobs Act, essentially what they said is that you can deduct interest expense related to debt of $750,000. So it's okay, just plan ahead. So long as your mortgage is $750,000 or less, the interest expense will be deductible if you itemize on your return. Okay, so please do plan ahead. And this was the homeowner, the second part of that, what if you were a landlord? If you have business use property treated differently than personal residence where you are homesteaded. For landlords, regardless of whether or not you refinance, it's still going to be an interest is deductible. And unlike your primary residence limited to $750 of debt, your business use property has unlimited deduction related to the interest, regardless of if you refinance. I very, very much appreciate your time. I'm sure there will be time for questions at the end. And at this point, I would like to introduce Ron Siegel, partner at Brinkley Morgan.
Everybody can hear me now, I hope. Thank you, Carrie, and good afternoon. It used to be that around May of every year, we would get very busy with estate planning because people were going on vacations and all of a sudden faced the fear of dying in a plane crash, and they would come in to do an estate plan or update their estate plan. Nowadays, hardly anybody is flying on airplanes, but because of that, COVID-19 is causing people to do more estate planning and more urgently than ever. Because unfortunately what happens is when somebody comes down with COVID, if they are hospitalized, it's virtually impossible for them to do an estate plan. They're not allowed any visitors. There's just no way just about that you can draft documents. So it's very important for people to address this while they can, and that's what a lot of people are doing. Now, an estate plan is not just a will. It typically consists of a number of documents. Some of those Sandy touched upon. Every estate plan should include a will, but in most cases, anybody with any significant amount of wealth is going to want to set up a revocable trust to go with it. The benefits of a revocable trust is that as long as assets are titled to the trust, the assets that the trust owns at the time of death do not go through probate, thus avoiding the expense and time delay that comes with probate. Probate is also a more public process. Your will gets filed with the court, and the terms of it would be available for anybody who wanted to go take a look at it at the courthouse, at least when the courthouse reopens again. With a trust, unless there's litigation, the trust document and its dispositive provisions are not going to be of public record, and therefore privacy is maintained. Another benefit of the trust is that you get to choose virtually anybody as your trustee who will administer your affairs after your death, as opposed to under a will, where if you are choosing your personal representative, it has to either be a blood relative or a Florida resident. So those restrictions don't apply to a trustee. The other benefit of a revocable trust is that it avoids the need for guardianship in the event that you become incapacitated. Should you become incapacitated with a revocable trust, the trustee steps in and administers the assets for your benefit. If you don't have a trust, then maybe if you have a power of attorney, which I'll talk about next, that might allow you to avoid guardianship, but otherwise your loved ones are going to have to go to court, set up a guardianship, and then the court's going to monitor all the activity of the guardianship, all of which comes with expense. So again, a revocable trust is what we would be recommending for most of our clients. The other documents that go with an estate plan include, as I said, a power of attorney, which is useful for assets that are not going to go into the trust. The most typical example of that would be an IRA, which cannot be owned by a trust. You may choose to make the trust a beneficiary of an IRA, but it cannot be owned by it. So if you became incapacitated without a power of attorney, your IRA becomes frozen and no distributions could be made. Another very important part of an estate plan is the healthcare documents, which typically consist of a living will and a healthcare proxy. A living will is a declaration that you don't want to be kept alive if you're terminally ill on a respirator with no hope of recovery. That is, of course, a matter of personal choice. Most, but not all clients choose to execute a living will. Hand in hand with the living will, regardless of whether you even want a living will, is the healthcare proxy or designation of healthcare surrogate, which is basically a medical power of attorney that indicates who you want to have access to your medical records and who you want to make decisions for you if you are not able to make those decisions for yourself. All of those documents magnified in importance because of COVID, because again, there's not time to do these after the fact. Other things that are part of estate planning, if the estate is large enough, is to try and eliminate or minimize estate tax. Now, currently, the estate tax exemption is $11,580,000 per person. And that amount is scheduled to be reduced in 2025 to half of that number, but it is subject to inflation adjustment. So presumably by the time 2025 gets here, we would have an exemption that will hit around 12 million, and that'll drop down to 6 million unless Congress takes action to change that. And of course, we do have an election coming up. So there's no certainty as to where the estate tax will go. The exemption amount has never really gone down in history. It keeps going up, even though we've had these sunset provisions before. But obviously, with all the benefits that the government has had to pay out because of COVID, there's going to have to be some tax increases somewhere, whether it will be estate tax, income tax, and when and how, of course, remains to be seen. Another important part of our estate tax law deals with what is called portability. That allows a husband and wife to use their two combined exemptions regardless of how their assets are titled. Used to be you had to divide the assets up between spouses in order to maximize the use of both exemptions. That's no longer the case. Now, in theory, you could have all the assets in one spouse's name, and if the penniless spouse died first, the spouse with all the assets could still utilize the other spouse's exemption amount. So tax planning is a very big part of estate planning. Also, in my last couple of minutes, I'm just going to touch on one technique, which is called a GRAT, because our interest rates are so low now. For people who are looking to transfer wealth and are facing a potential estate tax because their estate is large enough, a GRAT is a very useful technique right now. The way a GRAT works is you hypothetically take $1 million, you transfer it to a GRAT, and we'll say it's going to be for a 2-year term. And the GRAT is required to pay you back your $1 million investment, so to speak, as well as a minimum amount of interest rate, which again, because interest rates are low, right now you could have an interest rate of as low as 0.4%. And what that would mean is if you put $1 million into a GRAT, you would get back $1.5 million within 2 years. But remember, your goal here is to shift the assets to, let's say, your children, the next generation. And if that GRAT actually produced an 8% investment return, the heirs would receive $120,000, which would not eat into your estate and give tax exemption. If for some reason the stock market and the investments go down, so the GRAT doesn't have enough to pay you back the full $1 million, you get whatever's left in the GRAT, but it doesn't really cost you anything, and you can just start a new GRAT the next year or whatnot. So that's a very useful technique that we're using for clients at this point. There's been proposals to eliminate or GRATs or require them to be of a longer term, but right now you can do a short-term GRAT, and it's something that with this low interest rate is very worthwhile. At this point, I'm going to turn things over to Jessica.
Thank you, Ron, Carrie, Michael, and Sandy. We will now open it up for questions. The first question is, as the national debt grows, please estimate the probability that Roth IRA withdrawals will be taxed and or required, similar to Social Security, which is also funded with after-tax dollars.
I seriously, well, considering that the Roth is already paid with after-tax dollars, if they tax it again, the only way they would be able to tax it again is just tax the income on the basis or on the contributions. I doubt they'll do that, but it's always possible. Also for Social Security, if you, if they completely get rid of the Social Security tax for whatever reason, we've already paid into the Social Security system, and whatever we're owed currently, that we're still going to be owed that when we get to retirement age. That's an obligation that the government has already made. You can't go back on that. So I don't foresee anything happening in those areas.
So my name is Courtney Moberley. I work with Top of Mind as well. So we're just going to go ahead and keep the Q&A moving. So the next question that we have, Sandy, this one's for you. You mentioned to pick 5 companies to focus on. Does that mean that my portfolio should only have 5 companies? And what do you look for in a company to make it one of the 5? Oh, Sandy, 1 second before you start, you are still muted. There you go.
I'm sorry, can you hear me now?
Yes.
This modern technology. What happens is that it really depends on the person. Certain people have built their wealth up by having one company. Bill Gates comes to mind, or Jeff Bezos. Obviously, they've changed that as time has passed. It's really up to the financial advisor and that individual person and that person's household to see what meets their criteria. Obviously, the more money you have, the easier it is to diversify, and everybody should absolutely diversify and have a well-balanced portfolio. What's good today might not be good tomorrow.
Great. Okay, our next question is, what should the net worth of a family be to be able to hire an estate planner?
Do you mean estate planning attorney by that?
I guess so. The question is a little vague.
Okay. So as to, I mean, estate planning, does include, as Sandy has touched on, planning your financial estate. But in terms of the legal part of it, everybody has an estate plan right now. If you haven't bothered to sign your own will or trust, then you have allowed the state of Florida to create an estate plan for you, and that's called intestacy. And that often creates some very unexpected results. So there is no real minimum amount that somebody needs to have before they should have an estate plan, because they already have one, but it may not be the one they want. And even people without a lot of assets, another thing, if you have minor children, is to nominate a guardian for those children. Otherwise, the court's going to pick somebody.
Great. Okay, the next question, Carrie and Michael, I believe is for you. The person asks, I read that businesses will have to pay taxes on PPP loans. Can you clarify?
The PPP loan, as a general rule, is fully forgivable. There are caveats to that if you don't fulfill certain requirements. The biggest requirement is that right now is the 60% should go towards payroll. The rest can be spent on other specified things. If you spend money, and the PPP is not meant to expand your business. So if you use it to expand the business and the bank determines that that's what you were doing, you may have to repay the portion that you used to expand the business. Additionally, if you default on it during the time that you are supposed to be making interest payments, that could cause it as well. Finally, this is where most of the news has come out recently and saying that PPP loan is not as great as everybody thinks it is. You're going to have to pay taxes on it. What they're really saying is whatever deductions you took by using that PPP loan, currently the IRS is saying that those expenses are non-deductible. So you're losing a bunch of deductions on your tax return. So if you say, let's say you make you net $500,000 normally every year, and you have a PPP loan of $100,000 this year, and it's fully forgiven, that was $100,000 expenses that you deducted last year. You can't deduct this year, so you're going to have $600,000 of net income. So yeah, there's going to be a little tax on it unless Congress changes it, but you're still better off with the loan than you would have been without it.
Definitely makes sense. This next question is for Sandy. How often should I rebalance my retirement portfolio?
I recommend that most clients should review their retirement portfolio at least on a quarterly basis. A lot of people like to look at it daily, but sometimes that's not a good, healthy thing to do. But I absolutely recommend that everybody rebalance their portfolio at least once a year. Depending on market conditions, if we have an extreme amount of volatility, I would also revisit that and maybe do it twice a year, but absolutely unequivocally once a year. And I usually tell everybody to look at January 2nd because it's an easy day to remember.
That's a great tip. Okay, so our next question, Ron, I believe this is for you. Does a trustee have to honor power of attorney granted from a beneficiary of the trust to a relative? Same question, what about a bank?
Okay, so a power of attorney has to, in Florida, be very specific about what powers are being conveyed. And the typical power of attorney that I've seen, that I draft and most other attorneys draft, would not necessarily include the obligation to, or the power for somebody else to exercise a beneficiary's rights under a trust. It could be specifically drafted that way, and then the trustee probably would have to comply with it. The second part of the question, I'm assuming, is what if that power of attorney didn't go to a relative but went to a bank? Banks hate powers of attorney, and in fact, when drafting an estate plan, if a client is choosing to name a bank trust department as their trustee or personal representative, which is often a great idea, but you will find that banks will absolutely refuse to serve as a power of attorney. So I don't think a bank's going to be willing to take that on.
Okay, great. So our next question, what is the current estate tax exemption?
$11.2 million per person. If you're a U.S. resident, if you're a non-resident, it's $60,000 per person. For married couples that are both U.S. residents, if you don't use up the entire 11.2, the remainder transfers over to the surviving spouse, but that does not occur if you're non-residents.
Keep in mind, it is 11.2 million each. So if you've got a married couple, you've got 11.2 for each spouse. So 22.4.
It's 11.58. It's inflation adjusted. So it used to be 11.2, but it's now up to 11.58.
Yeah, adjusted for inflation.
Okay, great. Sandy, this next question is for you. When does it make sense to hire a financial planner? I own my home and have more than $150,000 in retirement savings.
I don't think it hurts to have a second professional, meaning somebody like myself or somebody else that's duly qualified to oversee your portfolio, to make sure that you're meeting your goals. And coupled with that, you really should have a financial plan to make sure that you're meeting your goals. There isn't ever too little amount of money because everybody has to start somewhere. And the more that you learn and the more that you view something, there used to be a company that said an educated consumer is our best customer. It's the same thing. You really want somebody to look over. It doesn't hurt to have a second set of eyes look over and make sure you're doing everything properly.
Okay, great. Ron, this next one's for you. Is a will or trust from another state valid in Florida?
Typically, the answer is yes, but they can have problems. One type of problem for a will is, as I mentioned, a personal representative in Florida is restricted to a blood relative or Florida resident. So if you have an out-of-state will that named your friend who lives in Kansas as personal representative, the will be valid, but that person won't be able to serve as personal representative. The other problem with out-of-state documents is they haven't factored in Florida law in most cases. So, for example, Florida has very unusual homestead restrictions, and if those aren't contemplated, that can result in unexpected consequences. So the bottom line is, if somebody has out-of-state documents, they should be reviewed by a Florida attorney. They may be acceptable, they may need to be modified. If you're a snowbird, you're going to want to be making sure that it's clear that Florida is now your domicile, and that may necessitate the change of documents as well.
Okay, great. Next question. Can estate planning documents be notarized online?
The answer to that is technically yes, under a brand new law that went into effect on July 1st. The problem, Florida started with allowing online notarization for non-estate planning documents January 1st of this year. So getting a deed notarized online is now fairly routine. But with estate planning documents, there are a lot of extra hoops to jump through in terms of verifying the capacity, if it's an elderly person, for example. And what's been happening is the online providers that you have to use to memorialize the notarization, they don't want to face the liability of taking the oath of somebody who may not be competent. But on the other hand, by law, they're required to be part of the process. So it's very difficult to get a will or trust notarized online now, but in theory it can happen and hopefully will be smoother to do. One other thing in that regard is that of all the estate planning documents that I touched on, although most of them customarily are notarized, the only one that has to be is a power of attorney. So if somebody doesn't have access to a notary but does have access to two witnesses, they can still sign a trust, they can sign a will, they can sign a living will and a healthcare proxy.
Very interesting. Okay, so next question we have here. If you paid cash for a house and you take out a mortgage later, is the mortgage interest deductible? I believe that's for you, Carrie and Michael.
The first $750 of the mortgage would be deductible. If you have a mortgage that's, let's say the mortgage is $1 million, just to make it easy, you would only be able to deduct 75% of the interest, because you can only deduct up to $750,000 worth of the loan.
And the advice there would be, ideally, if you had the cash available, I would want to make it so that if you put a down payment of $250 and the $750 is financed, then 100% of the interest would be deductible.
And then you could invest the money with Sandy.
Good call.
Yes.
Good job.
And then, so this next question is for Sandy, I believe. In these uncertain times, what percentage of assets should you keep in cash?
Well, it used to be, and again, each person's different, so you have to be able to sleep at night and you have to be comfortable. Right now, I don't want to speak for everybody, but most every investment that's done through a brokerage firm is 100% liquid. There are certain things that people might not be able to liquidate, like if they have money in a hedge fund, but usually that's going to the upper wealth class, so to speak, people with $5 million in assets and over. So the old formula was 3 months of cash reserves to meet any future emergency bills. But truthfully, if you're comfortable with your investments, I think a month is plenty, because if God forbid you really need money, you can always liquidate or borrow against it if it's in a regular account.
Very interesting. Okay, Ron, this question's for you. If someone does not have close relatives still living, who should be selected to administer the will or act as healthcare surrogate?
Okay, so to administer the will, the personal representative, which is also commonly called an executor, if you don't have a relative, it can be a close friend, it can be a bank trust company or a trust company that a brokerage firm has, and in other cases, it's a trusted advisor, which could be an accountant or an attorney. Usually financial advisors are prohibited from doing that unless they are a relative, but clients do choose their attorney or their accountant for that position. As to the healthcare surrogate, again, the bank trust companies aren't going to take that position on. So hopefully you have a close friend, because you really need somebody who is aware of your wishes and your situation.
Great. Okay, Carrie, this next thing is for you. First, I do want to say, someone asked if you can share your list in PowerPoint. We will include that in the follow-up material. But then we also do have a question for you and Michael. So you said that we can deduct home expenses if you work from home. Can you expand on that?
Yes. So when we talk about deducting things from home, Right now during COVID, this is a particularly interesting time. And I can tell you from a personal level, I'm taking this Zoom meeting in my home office. I can tell you that my husband is watching our webinar in his home office next door. And we normally do not claim either home office. And Michael is under the same, the same circumstance. And the reason why is, as a general rule, the benefit is very small and the audit risk is quite large. So generally we're not a big fan of claiming this. However, under COVID, everybody's working from home. So I would be much more comfortable telling you to claim home office now. The big things and what you're claiming, if you were to be audited, they would want to check that, like I said, this is exclusively used for business. So the big things: don't have a bed in your home office, don't have a crib in the home office, have it as a dedicated space. And then think about things that you pay that relate to your home office. Maybe you're buying supplies, maybe you're buying, maybe this is just a portion of your real estate taxes, or it's a portion of your rent. Anything that would be considered attributable to the business is okay. Where it gets a little hairy is that if you have internet, for example. What's to say that the internet is exclusively used for business? That's really kind of a little harder to argue, because I'm sure at some point you check your email, your personal email, you go on Facebook, whatever it is. So a little trickier to argue, but things like rent, things like real estate taxes, it's prorated based on the business use percentage of your home.
Also, you can deduct things like electricity. Technically, even if you don't have a bathroom in the home office, you could probably deduct water and sewer, because you still, we all have needs. And insurance, things that are attributable to your house, that even if they're not considered business expenses, but like your homeowner's insurance, you need to insure the house. So take a portion of that, what the portion of the home office is of that bill for the year, those types of things. So anything that's not personal, I would say, like internet and television, those things are really for personal use in your home. They're not, you did not get internet specifically for your business, or you didn't get internet for your television. You didn't get Netflix for your business. Those things I would not deduct, because those are personal in nature.
Okay, great. Sandy, the next question's for you. What's the rate to hire a financial planner?
Financial planners can charge in different ways. Normally we give a 100% free consultation to make sure it's worthwhile for the client to look at, to get a new set of eyes on it. Normally somebody like myself, based on the amount of assets, I might charge 1% based on their total assets, which includes free trading, and they get me for life or as long as they want me. They have my cell phone number. They can call me on weekends. I'm very, very, very open because I love what I do. That doesn't mean that it has to be 1%. Somebody might want a fixed income portfolio where there might not be a charge. Even though my firm might make money on a certificate of deposit, we're going to give what's always best for the client, no ifs, ands, or buts. And normally the free financial plan is included in what we're going to do. If it was outside and somebody just said, Sandy, I want a financial plan, I don't even want your services, et cetera, it probably, and please don't quote me on this, but it probably would cost somewhere between $500 to $1,500, depending on how intricate it is, because it can be as thick as a book sometimes. But our goal is to help people. We're not trying to have anybody complain this costs too much.
Great. Okay, so next question, Ron, is for you. If a husband and wife have all of their assets, so real estate and financial assets, jointly with right of survivorship, what are the advantages of also having a will?
Well, in that case, the advantage of the will would be if both parties, both spouses passed away at the same time or within a short time of each other. In that situation, the assets would all be subject to probate and intestacy. So when one spouse dies, that arrangement is fine. But if they both died, and obviously if one spouse dies, the surviving spouse is going to have a lot more to deal with than worry about running out and doing a new will the next day.
Definitely makes sense. And then there's another question for you as well, Ron. If you have a proper Florida will dated, 4 years ago and wealth is unchanged, at what point should that will be professionally reviewed and maybe updated because of ongoing changes to estate law?
Well, I recommend my clients review their estate plan at least every 2 years, looking for changed circumstances. And changed circumstances can not only include changes in their financial situation, but also looking at all the beneficiaries and fiduciaries named in the documents. Has somebody died? Has somebody become incapacitated, gotten too old to handle the position? Has there been a divorce? Have there been new grandchildren born or children? All of those things would require review at any time. And then it's generally good to have a review every couple of years. The laws change all the time, not just the tax laws, but also, for example, Florida's power of attorney law was completely revamped in 2011. So that necessitated updating those documents. So it's something that should be looked at, as I said, at least every 2 years or when there's a changed circumstance.
Okay, great. And then the next question is, are there any specific assets that you can depreciate?
Go ahead.
Well, okay, all right. Well, thank you. I'll just start by saying, if you're a current client, I can tell you that you have for sure seen something called a DR 405. If you are not, I recommend just Google it. You can find that online. A DR 405 is for tangible assets. I like to show it because it's a very good list of assets that are depreciable. Think about things like furniture and fixtures. Think about things like computers, iPads, Kindles, anything along those lines. There's a ton of stuff listed out. It's a great template. Take a look. Michael, go ahead.
Also, basically, if you can touch it, you can depreciate it. If you can't touch it, then what you're going to do is you're going to amortize it. And what is amortizable is a lot more difficult answer to come up with. But basically on amortization, it's like startup costs for a company, for loan points on if you have to pay extra for a loan. If you buy a company and the assets of the company are worth $100, but you spend $250, that means you have $150 of goodwill. You amortize that as well. So that amortizing is a lot more difficult to come up with what is a correct answer than depreciation. If you can touch it and it's less than anywhere between $600 and $2,000, or if it's more than anywhere between $600 and $2,000, you depreciate it. Otherwise, this is probably considered supplies and it's a current expense.
Actually, just to add to that really quickly, when you're planning ahead to depreciate, keep in mind that you can only depreciate items that you own. So for example, if you have a car that you lease, you don't depreciate a leased car because you don't own that car. If you own the car and it's financed, still okay, you can depreciate it. Definitely something that you can plan ahead for, and depreciation is a wonderful, wonderful tax benefit.
Okay, Ron, next question's for you. What do you recommend for couples who are not married but own a house and have 2 small children? This person has a regular will, but do you recommend that they go the trust route?
In most cases, yes. The house, unfortunately, is tied up by Florida's homestead laws, so they can't really deviate from that, and the children are going to inherit it. And they certainly need a will to designate guardians. And again, if they have any kind of assets, even if it's a few $100,000, they should have a trust for the children, because otherwise a guardianship will have to be set up for the children if both parents die. And that gets into a lot of expense and can really eat up a lot of that money over the time it takes for the child to attain majority.
And then another question for you. This person asks, my parents don't have a will or anything. How do I address this issue with them in a way that they don't think I am after their money?
That can be a tough process, but basically recommend that they go to an attorney and set up an estate plan and then kind of step back and try not to be active. Don't go to the meeting with the attorney. That's when the parent can feel threatened. I mean, in some cases, the parent's very happy to have their child come to the meeting, but if based on the question, there's obviously a concern that the parents might feel threatened. And in that case, I would say plant the seed with the parents and then step back.
That's great. We have another question here. Do you anticipate elimination of the step up in basis of an estate's assets on death under a new administration?
I doubt that's going to happen. I suspect if the Democrats were able to control both the House, Senate, and the White House next year, that what's going to happen instead is there's going to be an additional estate tax tacked on to what we currently have, and for very high net worth people, possibly $50 or $100 million, and so there will be a new tax rate for assets over that amount. But I don't think they're going to they're going to lower the current rules.
And I just want to make sure that we all know what that question was, because that question was a very smart question. I mean, imagine that somebody buys a property in 1960 and it was $50,000. If you at some point inherit that property and then now the new person that owns it goes to sell it, it's not that they're paying a tax on the sales price when they eventually sell it, less what that grandparent originally paid. You get a step up in basis based on the date of death. Or there's an alternate date where you can do it 9 months later if the market has been fluctuating, which means that that property that was $50,000 way back in the day, now the date of death, it was valued at $500,000. So when you go to sell that house, if it's your homestead, you've got an exclusion of $250,000 if you're single or $500,000 if you're married. And then I worry about you paying tax on it. Very significant and great thing to plan ahead for.
Just one other comment on that. Way back in about 1981, they tried the carryover basis, elimination of step-up basis, and it was a complete disaster because people could not figure out what their Aunt Millie paid for their Coca-Cola stock 40 years before. Nowadays, that may not be as big of a problem because the brokerage firms are required to disclose and report basis to the IRS, but still with a lot of assets, that can create a huge problem logistically.
And then, Ron, we kind of have the reverse of another question that was asked earlier. If you prepare a will while you are a Florida resident, do you need to revise that if you move to another state?
Well, it's kind of the same question. Every state's laws are different when it comes to all the estate planning documents we've been talking about. The federal tax consequences are going to be the same, but when you move to another state, most of those other states have a state inheritance tax, or many of them do, and they also, of course, you have state income tax issues. So the bottom line is you need to see an attorney in your new state to see if your documents need to be updated.
Okay, and I think we have one last question. I don't see anything else coming in. Ron, you mentioned estate tax portability. Can you kind of explain that a little bit further?
Sure. So before portability of estate tax came along, if the assets were not split fairly equally between a husband and wife, you ran the risk of losing the exemption or underutilizing it if the spouse with less assets died first. With portability, as I said in my presentation, even if, let's say, the husband had $15 million in his name and none in the wife's name, maybe it's a second marriage, if the wife died first before portability, her $11 million exemption went out the window and potentially costing $5 million in estate tax down the road when the husband died. But now the husband can elect to use the wife's portability, even though she had no assets, by filing an estate tax return at the time of her death. And now the husband would have the wife's full 11.58 of exemption plus whatever the exemption is in the year of the husband's death.
Okay, great. Well, I don't think that we have any additional questions. Does anyone have anything that they want to add before we wrap up here?
Thank you so much for having us. It was an absolute pleasure to be here. And for those of you who attended, thank you so much for joining.
Okay, great. All right. I just want to echo what Carrie said. Thank you guys so much for joining, to the attendees, and thank you to our panelists for joining us today. We appreciate you guys taking your time to give more information to everybody who had the opportunity to attend. So we'll get together a recording of this and we'll send it out. So stay tuned for the follow-up emails. Thank you guys all so much.
Thank you.
you.
Thank you for having us.
Thank you.